several hundred of you, so we're glad you're here too. But I will say it actually, I'm so glad we did. It was really valuable to have a global perspective to understand what's possible and use that lens now as we go toward the rest of the day with more of a focus on the US. So we'll take a 10-minute break now. For those of you in the room, there's coffee in the back, and we'll reconvene at 11:10.
Disappear and fully disappear. Example, or to escalate certain issues to the board level. And to me, there's value in that, even if, they say the D&O insurance paid the plaintiff's lawyer, like whatever money it paid it.
I'll add something. I share Bill's thinking kind of bigger picture. I share your skepticism that we can't expect directors to save the world and solve the climate crisis. They're not really up to the task. But I'm also equally skeptical of the political process. I'm a political scientist by training, and I am deeply, deeply pessimistic about even before the most recent election. I was deeply pessimistic about the capacity of the political process to address the climate crisis. So I don't think these two things are mutually exclusive. They can potentially be complementary. And they still might not be enough, even with the complementarities. But I think to abandon one or the other altogether is just, then we're definitely not going anywhere.
Tammy?
I just want to say quickly, if we're thinking about Caremark as either a conduct rule or a liability rule, I think about it differently. I think of it as solving a market failure and the question of information, right? So the board knows or should have known about these failures and shareholders did not. And so in that way, we're trying to address one very specific issue in the same way that we use disclosures or other tools to address asymmetrical information. And so maybe it's neither liability or conduct so much as just a sharing to address market failure, in which case I very much agree with Bill, like we are using this to bludgeon people over the head in a way that was perhaps not the intention.
Just a quick note or two. And I know that this isn't a civil procedure conference, but it's an important point I wanted to make in response to your observation. It is true that all of the Caremark jurisprudence has been developed in the motion to dismiss context, but therein I think lies the practical problem. Because once a motion to dismiss is granted, the case becomes automatically settleable in non-figures. And the Boeing case is an interesting one because we say there were these compliance errors. I don't know if they were or they weren't, but that lengthy decision that was written by the Court of Chancery was based on allegations by plaintiff lawyers who were just telling a story, the one side of the story. It became the story that was adopted. And I carry no grief for anyone in that case. And obviously underlying it was a horrible tragedy. But after a Caremark claim is motion to dismiss is granted, it becomes this really quite unfortunate theater where everyone pretends to litigate when they settle within policy limits for a very significant amount of money, and you never know what happened. Beyond that is the broader systemic point, though. No one wants Boeing or any company, but especially Boeing, to be operating in non-compliance with regulations. Whether they did or we didn't know. But over the course of years of operations, companies are trying to make money. You need to expect them to do everything they can within the law to do that. If they've gone beyond the law, sometimes they're caught, sometimes they're not. What I'm trying to put pressure on is the idea that there's a real tension between these obligations. And I'll say finally that please don't, I wrote a little piece earlier last year, and the thrust of it was that in my judgment, we need to reconceive of fiduciary duties so as to permit directors to consider things beyond value maximization as part of their overall remit. That's where I think it needs to land, not without any responsibility, but recognizing that what directors are generally are good people who should be empowered to do good things in the world. That's what we should have our corporations doing. But I think we're putting them in intolerable straitjacket with the way the law presently is configured.
At this point, I do have some follow-up questions on this, so we may come back to it depending on enthusiasm from the audience. So I'm gonna open the discussion to folks in the room. Oh, excellent. This is great. I'm seeing lots of hands. Put your hands up a little higher so I can make sure. So I'm starting in the back.
Hi, thank you. My question is specifically to Bill. So you really gave an overview of directors' responsibility being driving value and reducing loss. What do you believe is the role of harm taxation as a way to entitle directors to global responsibility? And how far away are we from that being a reality at a global scale? Harm taxation. So thinking about climate impact.
I'm going to confess that I have no idea. Honestly, and this is what I mean by saying, maybe I'm not the right guy to answer these questions. If though the idea is, should we have a legal, and I'm not sure it's right, I don't even know, but that we should have a regime in which corporations are answerable to some sort of taxation regime for externalities, for negative externalities that cause, like climate damage. I have no idea how close we are. As a policy matter, provided that it was predictable and rational, I have no objection to it. I do think a legal regime that in a predictable, rational way that is not unfair to the individuals who are independent directors and always are going to have imperfect information should be answerable for their negative externalities. That seems to me to be a sensible objective of a legal regime. So I hope that's responsive to your question.
Andrew?
Thank you. So Bill, in response to your comment about your hopes for the future of directors' duties, I guess I'm curious if you think that we should basically say, or hopefully the Delaware legislature should say, that all corporations should be public benefit corporations, because that's where that is already in the law. And is it necessary to have the Delaware legislature take that position? Or is that the direction we're all going anyway? If we look at what artificial intelligence companies are now doing, they're all going towards public benefit corporations, presumably because they've recognized that that gives their directors much more substantial flexibility in interpreting their responsibilities.
It's a great question, and I don't have an answer. I think, having not had the opportunity to puzzle this down to the ground, that there remains, even in my conception, a place for the C Corp and a place for the B Corp. I do. I think there can be a difference, and I think it might matter to investors, and it would matter to directors. I think the public benefit corporation has a bright future, though, and I noted the reference to the end of history for corporate law, which has always entertained me and not. And I think the arc of that history is bending towards the benefit corporation and a more flexible, and even in the C Corp context, a more flexible attitude towards what we should expect of our directors.
I'm going to broaden that question just to see if the panels pick it up, but just how do B Corps and C Corps perhaps change the exercise of fiduciary duties on climate for either the officers, or if you're a C Corp shareholder in another company and have a board seat, and maybe change your how those duties are exercised, if there's any appetite to broaden the question on the implications of that.
What was the second part of the question?
The second part of the question was just both from the perspective of the duties of a company, both from the perspective of directors and officers. But if you are a director of and a shareholder on behalf of a person who's operating in the role of a shareholder on behalf of a company that is a C Corp, that I'm curious about also how that would affect it. So not just whether the company in question is a C Corp, but maybe the shareholder in question is a C Corp. So I could see it being both ways, just to kind of broaden it. I'm going to field another question if you want to folks noodle on it, but I don't want to pause it, but I wanted to open the topic of C Corps a little more. Gentleman in the back with the blue, and then the gentleman right in front of you.
Hey, well, my name is Luis. I'm from Indiana University. I'm not from law school. I'm from the business school. And so my question is just connecting what Bill and Roy was mentioning and going back to my experience interviewing board of directors. And for example, Roy mentioned about the EU directive from moving from business to the legal risk. But it seems that in the US, the directors are already thinking about the legal risk. So when you interview them, they're always thinking about what are the legal implications of their decisions. When you go to Europe, that is not as much. So eventually, this is some a current reality in US right now. I mean, to my perspective, I'm not a lawyer. Well, I am, but I don't practice. But so this is my question. Is Europe actually going towards this more legal perspective of responsibilities that in America we already have? And connecting with what Bill just said, I mean, we are turning from business decisions to legal decisions, the role of the boards.
So should we take it? Yeah, please. All right, so thank you, Luis. So I guess the point is that there are only so many issues that the board can discuss, right? The board is limited in its capacity, right? And the issues is what will make it to the agenda, what will make it regularly to the agenda, what will be the responsibility, what will be the board structure, responsibility of committees, what kind of committees you have, what will be the board composition, what types of expertise do you want from your directors, and so on and so forth, okay? Now, when they're considering legal risks, there are certain risks that are more central, and these are more relevant to Kermar cases. And there are risks that are more incidental, and these are not relevant to Kermar cases, and boards don't take them into account when they structure committees or where they select individuals to sit on the board and so on and so forth. And I guess the point here is that at least up until the CSDDD, and we don't know if it will change, but at least up until the CSDDD, the Kermark channel wasn't really doing any work in pushing boards to think about climate, okay? Following the CSDDD, the Kermark channel could be doing work pushing boards to think about different board structures, how to allocate responsibilities within committees, different board compositions, what types of information we need to escalate regularly, like every 2 months or whatever, once every 2 years, I don't know, okay? So this is how I see the process of change happening.
Sarah.
That boards need to?
Change?
How can you
Sorry,
say-
AI and cyber attack.
Of course.
Yeah. Do they need to be thinking about demographics? Do they need to be thinking about politics, misinformation, disinformation? Because they've only got limited bandwidth and they've got incomplete information.
I mean, I think this is.
Why
so-
then do they not need to be thinking about a risk that the World Economic Forum calls out as 5 out of the top 10 risks to the global economy? Why do we treat climate change as a financial risk any differently? And why shouldn't well-paid independent directors be called out for their failure to govern the number one forward-looking risk to strategy and risk-adjusted returns? Why?
So I think some of it, Sarah, is the practicalities of derivative litigation, and I'm talking about the US right now. Okay, derivative litigation is predicated on the company suffering a trauma, right? And then on you as a plaintiff attorney managing to link the director's omissions or lack of effort to their trauma, right? And unless you have kind of a big regulatory sanction or something like that you can show a trauma, it will be very hard for you and your plaintiff's attorneys. These are basically entrepreneurial plaintiff attorneys, right? And there's not much purchase in going after Kermar claims for you not reversing climate change in a specific company. So that's just the practicality of derivative litigation, of private enforcement. It doesn't mean, and we had the question about the tax. Your panel finished with a question about the cocktail of different legal instruments. So if the question is about what is the added value of corporate law, this might be also a response to, in some ways, to Bill. The added value of corporate law over other public law regulatory instruments is that it could generate accountability at the top level decision makers. Regulators have incentives to settle with the company. It's easier. You get to open more enforcement actions, you get to collect more money. So they settle at the company level. If for the company it's just the cost of doing business, you have no accountability at the top level individual decision maker. If derivative litigation is calibrated properly, and that's a big if, then you will get these bounties to these bounty hunters only if they manage to show that the top level individual decision makers weren't doing their job. So that's the added value in my view.
It's a fair question. I think at a very kind of practical level, I have two observations. One is that independent directors are, I don't know how well they're paid, but they're pretty well paid on the one hand. On the other hand, no one takes that job. I think they're very that's one of the reasons that we don't sort of change the rules a little bit. It's never going to work. And it goes back to my conception to this problem of it being everyone's problem and therefore no one. So it's a collective action issue, and at the director level and the platform level. So I think it's a little tough one, but I think as a practical matter, it's going to be very hard to have it.
Hi, I'm Eric from Wharton, also a business school, but I'm a lawyer too. I'd like to pick up on Bill Savitt's point and agree wholeheartedly with it, but also put it in context. I don't think it's a new idea. And I think we'll talk in the next panel about the Burnley-Dodd debate, Martin Lipton's work, and who had advocated something similar. And I think, and this also goes together with a comment for Professor Etheridge, because there's not going to be federal action on this. I think there really is a large possibility to try to move the fiduciary duty standard back to, I think it's going back to a standard where you did not have the profit maximization virus. I don't think the problem is what one of our notorious graduates from Wharton calls the woke virus. I think the virus that we have to worry about is a profit maximization virus. And to flip a little bit, Bill, what you said about how directors are thinking, I think there really is an appetite for directors, managers, top CEOs to care about this issue of climate, but they feel constrained for exactly the reasons you are giving them, because there is a profit maximization idea that has somehow become a fiduciary duty that cannot be moved. And I think just to let Paul Hawken, just to throw one other idea out there, Paul Hawken once said 20 or so years ago that there's no polite way to say business is destroying the world. So it's not just about saving the world. It's about the fact that if you're just following profit maximization rules and you're not allowed legally to consider the fact that we are destroying the earth, destroying the climate with massively terrible effects, I don't see how that can be a reasonable person, reasonable director, or reasonable investor standard. That's not reasonable. So I think we should change the laws and maybe go in a state direction of changing fiduciary duty laws in the US.
Madison, you were eager to follow up on the topic.
Well, I guess, I mean, the title of the panel has the word adaptation in it. So I just would love to hear like more musing on physical risk as a duty in the boardroom. I mean, I just don't have to be that creative in my head to think of all sorts of possibilities arising to Caremark pseudo level duties. And I would love to hear a response like, last year, Warren Buffett's letter to shareholders basically said something crazy, which was like, inevitably, all of the utilities are going to have to be owned by the government because like they're going to be too exposed to wildfire risk. It was like a throwaway line. And so I'd love to hear more about how you think the like ecosystem of compliance works with outside auditors and inside board duties about like assessing physical risks, which are rapidly mounting.
I mean, I think that certainly they have duties to address physical risks that are material to the company's bottom line under existing law. I think that's sort of indisputable. Basic principle, yeah. I don't have too much more to add than that.
Fiduciary duties work exactly as they're supposed to in those cases, because the climate changes are expected to impact your bottom line in a very like clear cut way. And so in that way, you have to be preparing for them in a way that maybe we don't expect. I don't know, the local bakery or something to have to prepare, right? So I think it depends on the industry, and the expectations will vary based on the industry and what the business judgment will expect us to in that space.
I also, this also goes back to Sarah's point. That it's obviously, if there's a physical risk in this material, they must consider it. But practically, if there's no harm, if there's no trauma, after there's harm, there's trauma, that's a clear karma case. If there's no harm, if there's no trauma to the company right now, no entrepreneurial plaintiff attorney is going to take this case through the derivative litigation, through the Caremark machinated. So we're talking about different legal instruments here than the Caremark instrument.
And also just as a follow-up issue on the physical risk part, just to take a moderator's prerogative, I think there's an issue here where there will be say there's an instance, fact pattern, big catastrophic 1 in 1,000 storm. And the historic data reflects the fact that it's a 1 in 1,000 storm, but model data suggests it's a 1 in 10 chance. Yeah. And so can the board rely on as a defense to that litigation that they neglected to adequately prepare for that risk, that it was, in their view, it was only a 1 in 1,000 chance because they were looking at historic records and they didn't have an obligation to look at modeled information that suggests that it was far, far, far more likely. I wonder if that's the sort of core conundrum of physical risk, because to the extent that these are reflected in historic record and it's not climate change, then you always have this shield that like, well, we just didn't know it was ever going to be that bad, even when the damages are real. I just wonder.
This is kind of a basic corporate law topic that was yet to be decided in a Caremark context, which is reliance on advisors or someone giving you an advice saying it's a 1 in 1 million where it actually wasn't. And it raises an issue of like, can you bring aiding and abetting claims in a Caremark context, which is the director failed because someone else failed them. And in general, just again, it's not thinking about it in a kind of an intuitive way, but thinking about it in a corporate law way. Aiding and abetting liability doesn't work well with Caremark liability. This doesn't work well because the conditions for aiding and abetting is that it has to have a predicate breach on the part of the director, and then you have to have knowing participations on the part of the advisor. Now, if the directors had someone advising them and showing them model about what is the risk, it means that they didn't breach their Caremark duties because they were already proactive. And so probably you're losing your aiding and abetting space on that end. So again, I'm just talking about the Caremark instrument. There are many other instruments that hopefully could address it. I'm not that optimistic about the Caremark instrument addressing it.
I'll just make one distinction between standards of conduct and standards of liability. So you can imagine that the standard of conduct might require you to use the best model you have, but that doesn't mean that you'll be held liable for failing to do so. Caremark, even notwithstanding the various developments that have made it easier for plaintiffs to prevail on a motion to dismiss, still only requires you to try. It doesn't require you to exercise best efforts.
I want to shift to online because I know from Martin that we have a few questions there. I don't know how much we have there, Martin, but if you want to share one from the.
Yeah, I'm going to, again, take a quasi-moderator's privilege to synthesize a little bit because we have a number of questions. We have just little over 100 attendees online right now. So we've had a number of questions about the way that fiduciary duties incorporate time horizons and scope of consideration. And it seems like this overlaps a lot with some of the discussions about bleed over between jurisdictions, also the discussions about adaptation and the extent to which companies are considering current risk versus future value, et cetera. So can people talk a little bit about how they're seeing the kind of time horizon issues play out in interpreting directors' duties to whether to shareholders or other constituencies, and how they see that playing into this broader problem of, I guess, board adaptation to climate change?
Yeah, I mean, I think like thinking about time horizon issues is thinking about what's your discount rate, and that's going to be such a difficult question to answer, and largely in terms of liability covered by the business judgment rule. So I think those sorts of issues are going to be within the zone of discretion that the board of directors has.
I guess part of what the some reason it doesn't work. Part of the what the EU legislation, the CSDDD, the CSRD, which is about reporting, does is that it escalates to the board level long-term oriented risks that maybe the board didn't want to or couldn't or didn't think about discussing earlier. So in that sense, to the extent that it is really implemented, it will make the board, going back to Louise's point from before, will make the board discuss more long-term issues.
Quickly, it's an interesting question, a fundamental one. After that, Mike. It's an interesting question and a fundamental one, but fiduciary duties are designed to protect permanent capital, so that's kind of forever. Could, as a director, justify a decision on something very far out, but investors aren't investing forever. And if you are the company that's really going to kill it in 150 years, but it's not going to do well for the next 20 or 30 or 40, you're not going to be a director very much longer. And that's the practical reality.
One more from online.
Yes, so let me see. Maybe move to remote
Okay, yeah,
and
sure.
another
Yeah,
one
yeah.
from online.
Gentleman in the.
Thank you all for being here. I was wondering if Delaware, if the legislature were to adopt, or there was a fiduciary duty law that included climate risk that was material enough to have an effect on the climate crisis, would that prompt companies to just reincorporate elsewhere, especially ones that duty negatively affected their business substantially? And in another state, for example, and we're seeing a little bit of this happening. Do you think that's a real risk or not?
Yeah, I mean, I think there's always a risk when you're trying to impose too much under state law to consider sort of interests beyond the interests of the shareholders that companies are going to flee Delaware. So that's definitely a risk. And, Delaware has been caught in this push and pull between the risk of federalization of corporate law and other states trying to take their franchise away. So it's always sort of caught between those two things, and both are constraints on what they can do as sort of a political, practical matter.
So Roy's point about sort of the marginal benefit of Caremark is based on some assumptions, and I was interested in hearing maybe Bill's reaction to those assumptions. I'm sorry. But I mean, as you've been saying, there has to be some sort of corporate trauma for these Caremark cases to arise, some major penalty that the EU has chosen to impose in the case of the due diligence directive, or some, horrible event like happened at Boeing. And there's always also going to be securities litigation that follows from that. And so it just strikes me that maybe directors already have a lot of incentives to take steps to prevent those sorts of horrible things from happening. And I just don't know how much the threat of a 220 request and a Caremark case is going to move the needle. But that's your assumption. And so I just wonder, Bill, what you think about that based on your interaction with directors and your advice.
I don't think that directors are worried about Caremark liability now because there have been some high-profile Caremark lawsuits that have survived a motion to dismiss and yielded accordingly high settlements that are high dollar. They're high impact reputation. So they're worried, but they're more worried about the thing that caused it, the airplane crashes or the scandal or the hysteria outbreak. And I think that my take on what's happened with Caremark is that it's a response by the courts in Delaware, understandable, to try to navigate the value maximization issue. Because what legal regime wants to say, just go make money and don't care about people? And this is a doctrine that says you also have to care about people. And it's in tremendous tension. And I think it's not long sustainable, because I think there really is a tension. And I don't think the effect on directors really is changing their conduct, because they're trying to run profitable businesses. They're taking advice, and sometimes bad things happen. And if they're going to be answerable once or twice, not much more you can do. It does allow lawyers, though, to bang on much more in the boardroom. That would otherwise be the case. And that's probably a good thing at the margins from a prophylactic perspective.
Okay, thank you. Yeah, actually, this is a follow-up question. Sorry, I'll move over here. On advice, I'm wondering, I'm looking at OSFI, the Office of the Superintendent for Financial Institutions in Canada, and they're calling climate change a transverse risk because they see that it goes across business risk, financial resilience, operational resilience, and risk governance. And they are now using that framework in evaluating the credit risk of all of the institutions under their supervision, all of the big banks and the pension funds. I'm wondering, but is the problem when advising companies that we don't yet have enough specific, company-specific evaluations of how these transverse risks actually eventuate in a particular company in a particular geographic location with, their supply chains, in X, Y, and Z? So if you're advising companies, of course, the reason the company is making decisions is to try to advance their long-term economic output. If you can show, should we be doing more to be able to show companies, oh, look, this is the specific risk you're running, and that's why you need to encourage it, consider it now, not necessarily ex post Caremark.
Any response?
I can have a quick response, not answering directly to Cynthia. I don't think that the question was directed at me, but just to tying it to Amanda's previous questions and Bill's comment. I think that, of course, let's say if we go back to the Boeing example, of course, directors don't want airplanes to crash. Of course, they want to have a good safety record, but they also prioritize, and they want to beat the French. They want to beat Airbus in the competition. And so there's a dynamics of willful blindness, meaning I want you to beat the French. I want you to get this new model out quickly. I want you to get all the regulatory improvements quickly. And if I don't have, exactly like Bill said, that the lawyer being empowered to tell me, listen, but you also need to discuss these and these issues, or in our case, the climate issues, the climate risks, to the agenda. And in that sense, I think that the prophylactic value that Bill said is a good thing coming from Caremark, in a sense that counterbalancing somewhat the willful blindness dynamics on the issues here of climate risk.
Hi, Matteo Gatti from Rutgers Law School. We're living in an era where our legislators, regulators, policymakers in general are under a perfect storm in the EU and in Delaware. So narrowing it down to this panel, I was curious to know what people think about Caremark not being one of the things that is about to change soon in Delaware law. Because as Bill said, there are several problems with the doctrine, but legislators not intervening there. Why is that so? And what are other states doing with Caremark type of obligations? Are they competing? Is that an imperfect feature of Delaware law that other states are trying to get advantage from? Thank you.
So I can say that that judges in other courts loved the mission critical analysis, and they're applying it in many aspects, like the opioid pandemic in other states and in federal courts. But on your point, so the point being, I lost my train of thought. The point being the first point of the perfect storm of the regulators. So to me, and this is going to be maybe too much inside baseball of corporate law for this crowd, but to me, the proposed changes to Delaware corporate law do affect Caremark, do affect the risk of Caremark liability, because everybody's been discussing the changes to transactions with controlling shareholders, but there are also changes to Section 220 and to shareholders' rights for information. And the change is basically you're cabining the documents that shareholders can access just to core formal materials, right? Like financial statements or board minutes and so on and so forth. And if you didn't have access to informal communication, say in Boeing, you're not able to show that these directors coming from a pharmaceutical company and they knew that the Boeing never had discussion of safety issue, even though in the pharmaceutical companies, every meeting they started on safety issues and regulatory risk issues. So plaintiffs had the emails in Boeing, and this is what they came, like Bill said, with the story to the court. Court made inferences in their favor in the pleading stage, at the pleading stage. Going forward, if this proposed bill really amends Section 220 like that, I think that the prospect of Caremark liability goes down.
I would
respond to that quickly. Well, maybe I'll let the Chief Justice respond.
It feels like the laboratory frogs up on the table, but mission critical was designed as a limitation.
Right.
Not it was designed to say directors don't have to. I'm using my litigator voice. So I hope people can hear, but okay, like Freebird. Okay, is mission critical was when you're an ice cream company and you make ice cream, the safety of it is pretty clear. When you put things in the air that fly, every company, every person, there's a lot of legal regime. So it was actually a limiting and rooting. There were felony convictions of the company in Marchand. There has to be a liability standard to enforce it, but Bill Allen set it very high, as Bill said, so it would be extreme. And it was to deal not with malum prohibitum, like I've told my friend Steve Bainbridge, let's stop talking about parking tickets. But one thing you haven't actually talked about is the bottom line of the legal regime in the United States. Lawful business by lawful means. And it really is getting at, are you trying to make money by intentionally doing something wrong? And are you presiding over something? But on the basis for informational basis, you're just not correct for this reason. The government in most of these cases, right, Bill, develops the information. The information exists. The plaintiffs are not the heroes of history. They're not proving the wrongdoing. And in Massey Energy, I thought the plaintiffs came in and said, you know, we want to do this. The government hadn't done the liability yet. And I said, you're investors. Why are you rooting against the company? And how long have you been invested? For 10 years, Your Honor, and this company's always violated minors' rights. So they've been violating minors' rights, and your clients have done nothing about it? That's not what Caremark is freaking for. But on the books and records thing, Roy, if the minutes don't have any discussion of the material risk, that is evidence. And in Boeing and actually in Marchand, it was the absence of effort under the standard thing. So you don't need to have 7,000 text messages. And by the way, if there are 7,000 documents about the board trying, there's no liability. So we have to be real here.
And I'd urge professors to actually look at some of the cases. And Bill's exactly right, that a regime where you just have excessive costs and no actual liability on the part of people, it's really supposed to be an indemnity claim, is probably not the answer to societal best behavior. So sorry for that, and I won't be talking about it in 20 minutes, but I figured.
If I can just make one more addition, I agree with what the Chief Justice was just saying. You know, there are two prongs to Paramount. The first prong is, did you set up the system? And the 220 amendments, I don't really see that affecting that prong at all. So to the extent they have any effect, it'd be on the second prong about ignoring red flags. Because you could imagine, in theory, there might be some emails that suggest, oh yeah, we did come to this information, we ignored it. So perhaps the amendments could have some effect there.
Tammy, you.
I was just gonna make a brief point as well, that I think we have this oversized perception of Caremark. In the history of the doctrine, there's only been 4 or 5 cases that got past the motion to dismiss. And so I'm not worried about the 220 amendments and the way that maybe Roy or other corporate scholars are, because in my mind, those cases are for the most extreme situations, and those will still continue to exist regardless of the 220 amendment.
One word about mission critical as the limiting factor. Of course, I agree completely. I'm just, in regards to the European directives, what we say in the paper is that, for example, the directive includes a provision that excludes you from public procurement. So if you're a company and a big client of yours is European governments, and you're not even discussing compliance with the CSDDD, that's probably a mission critical risk for your company. So I agree, it's a limiting factor. But
Your paper is great, and I circulated it internally. It's a real
Very good.
good thing.
Thanks.
Just one interesting thing, Bill, you mentioned earlier, this is everyone's problem. And then Sarah, you said sort of, this is like every other risk. And I wonder if the conversation leads me to question whether we want to challenge both of those, which is to say, are there certain companies for which this is not, just from an enterprise risk standpoint, this is not like every other risk. Maybe it is a mission critical risk for a subset of companies, depending on which subset of climate related financial risk you're talking about. And then maybe it is not like every other risk. And maybe our narrative has emphasized, well, it's just like everything else, but actually that's not the right threshold, because there's lots of risks that are enterprise risks that the directors and officers can ignore under the business judgment rule, but there might be extraordinary risks like AI disruption, where climate or some aspect of climate risk falls within that. So I just wanted to offer up flipping the lens on whether we think of this as everybody's problem or some companies and some directors and officers' problems, and whether we think of it as just like every other risk or a really, really unique one. So we have time, we're at the 5-minute mark, so I think we have time for one or two more questions. Danielle?
So just to follow up on that, just something Bill had said, which is saying the directors don't need to save the world. I would agree. It's not their job to save the world, but they are contributing to the risk, which in the end will impair all companies. And it's not a 150-year timeline. If you look to the insurance companies, we're already seeing the first climate-related financial risk sweep the nation. So that is current. So the question I have, and I'm not a Caremark expert, but certainly companies are contributing to risk, each one, some more than others. So, and I think probably oil and gas companies have significant litigation risk, and they should be considering climate change. We are looking to insurance companies who continue to invest through their in harmful companies that are creating risk. So is there a joint and several? I mean, I don't know how you take the individual contribution, because each company is contributing to the harm that will impact their company. Climate change will impact every single company in some way. So I was just wondering about those issues.
I would say my fear is that once you get into all companies are contributing in some way, that then it becomes a political issue. And so you start to lose large large groups of, or a certain amount of buy-in that would encourage legislation or regulation in the space, something that would be more effective than Caremark litigation, for example. And so to me, it seems like a especially important issue right now to name specific industries and to say, when thinking about Cynthia's question about the timeline or time horizons or things of that sort, that we're going to look at insurance, gas, coal mining, cobalt mining, what the very specific industries that we can, meat packing, agriculture, right? That we can say, we know you are having this specific impact and data shows it, and move litigation forward in that way as a practical tool, right? Before going into this carte blanche, all corporations are bad, in which case now we've lost 51% of the population, and we're not going to get legislation or regulation or anything that would move the needle forward at all.
Any responses to that or final comments? Because I think we are gonna wrap as lively and fun as this is.
Yeah. Yeah. I do want to ask the question. Okay, we do have this Caremark doctrine, which actually lays down, I think, the minimum thresholds rather, that you need to have internal controls and like red flags if you have. And you do have overall, I think, the traditional approach of Delaware courts, which actually focuses more on shareholder primacy. So I think directors are in a way actually, concerned much about the traditional approach. We do see a lot of like, I think, the Meta's case recent, which was 2024 case, which actually focused again on shareholder primacy. So I do want to ask whether Delaware courts need to actually rethink on their like interpretation, or is there a need for judiciary to actually fill in the gaps to actually take this agenda of climate forward? Because until unless, I don't think we do have a like corporates do actually are risk free from like their liabilities perspective in courts. They are actually going to take this forward. So what's actually needed on like judicial front or some creative approach? Can you just throw light on that? Maybe, yeah.
I'll allude to my comments earlier. I don't know if this one's working. To my comments earlier about the constraints on Delaware due to the state competition for corporate charters. If Delaware goes too far, it's going to lose corporate charters to other states. Companies are going to go to Nevada and other states like that. Now, it has some wiggle room due to network effects and other sorts of things that maintain it's due to its excellent court system. But I would just be cautious about relying too much on Delaware to address these sorts of issues.
I think we're out of time. I am so grateful for having such a lively audience with lots of questions and comments, and especially to the panelists for thinking on their feet and engaging in advancing our thinking on the topic. Please, a round of applause for them.